Order 41 applications, please hand.
Order 41.
Order 41 applications, please hand.
Application.
Hearings not now, later on.
The application.
Yes.
Application for inclusion.
Lordship, I'm mentioning upon notice there has to be a correction in the order.
Correction, yes, please.
For inclusion in the list. First appeal.
Appeal, no. Only application order 41.
Included in the list of a contempt matter.
It's an application. Contempt application.
Contempt.
Yes,
Contempt
handover.
Application
Of this bench.
of the bench of Honorable Justice Bhattacharya with Honorable Justice Bhattacharya, Supratim Bhattacharya.
Hand over the slip whenever the bench sits.
The order also.
এটা একটু আলাদা করে দিয়ে পাঠিয়ে দেবেন ওই
Lordship,
সঙ্গে আমি ঠিক করে নেব।
Lordship, the correction in the order has been given by Honorable Justice Harish Tandon.
With sitting with?
Justice Madhuresh Prasad.
Just since Justice Prasad is there, it has to be constituted by a bench of Justice Prasad and somebody else. So mention it before Justice Prasad with the leave of the other judge so that he can constitute it. If one of the judges is available, it has to be done by that bench.
Justice, kindly leave may be granted.
No leave is required for that. Mention, just like you mentioned before me, mention before Justice Prasad.
Gratefully, Lordship.
Thank you. Next. I will call on the list.
No, 1 minute, I am for the appellant, Milord.
You have to put in special messenger within a week, did you not?
No, Milord, I have filed an application for modification of your Lordship's order dated 11/3/2025 because of the reason that...
Why is it appearing as to be mentioned? Anyway, what is the application for?
Application for, Milord, application for modification of your Lordship's order dated, Milord, 11th March.
No, but have you put in the special messenger costs?
No, Milord. As of date, Milord, what has happened, Milord? Milord, I am...
You're seeking a modification of that order?
My
Yes, what is the modification?
Milord, your Lordship, if your Lordship kindly takes pen of your Lordship's order dated 11/3/2025, Milord. Milord, kindly, your Lordship has...
What is the order date?
11th of March.
Which page number? Very well, got it. Yes. Last order. Yes.
Milord, your Lordship has, Milord, considered that at the time of hearing of this application, Milord, on behalf of the Milord respondent, Milord, they have submitted a documents, hand of a documents, Milord, with relates to the Milord relaxation of condition of bail of the appellants, Milord, wherein the division bench of
bail.
Yes, Milord. Milord, kindly consider. Your Lordship has also, Milord, observed this.
Which
Milord,
page? Which para?
Milord, next second paragraph, Milord. Milord, the second page of the order, Milord.
Which para?
Orderটা কোথায় যে
Bail.
Appellant before your Lordship's, Milord, filed an application.
Let us show us the paragraph where you have stated that.
Milord, this order, Milord, I have missed, Milord. Why, Milord? On the file, Milord,
Yes, learned counsel for respondent submits that such claim is palpably belied since the relaxation of bail was obtained on the sole. Yes.
Milord,
So what?
Milord, this is, Milord, on
No, that was the premise. We did not do anything about the bail. You obtained relaxation of bail on the condition, on the ground that you were running an embroidery business.
Milord, that is the point, Milord. That's why, Milord, Lordship hold it is a commercial. You are using a commercial.
Yes, yes.
But it is not a true fact, Milord. Milord, I have annexed in the modification application the commercial portion which we are running. That is in separate, Milord, suit premises.
You should have pointed that out. It was heard in your presence.
Milord,
The order was passed in open court.
Suddenly they handed up a documents, Milord. Thereafter I searched. That's why, Milord, this application has been mentioned, Milord.
No question. You put in the special messenger cause this application.
Milord,
serve a copy of this application on the other side.
Milord, considering this, Milord, this aspect, Milord, your
serve a
Lordship
copy of the application on the other side.
Milord, as of date, Milord, since your Lordship, unless your Lordship grants me leave, Milord, that's why.
You're granting you that leave.
Milord, I shall, Milord,
serve a copy, it will appear as an application, but you have to put in the special messenger cause as a condition of this order.
But, Milord, your Lordship also passed an order directing me to, Milord, pay, Milord, 30,000.
That remains,
Milord,
unless we hear the other side.
Milord,
That remains.
Milord, 30,000 considering.
That remains unless we hear the other side.
Very well.
We cannot pass an ex parte order on that. You are present in court.
I am not paying for ex parte order, Milord.
It transpires from the office report that the appellants have not yet put in the special messenger costs as directed by your order, earlier order. Push up, the appellant is directed to put in such. No, the respondent was to put in. Respondent was to put in. You are not prepared in the matter.
That's why, Milord, they also file an mention before your Lordship for to be mentioned.
Very let a copy of this application be served on the.
Milord, I have served, Milord. Milord, I have served upon Milord.
If you have finished, let you pass our order. Let us pass our order. There was no direction, you could not serve. The appellant shall serve a copy of this application on the learned advocate for the respondents, indicating that the matter shall be listed tomorrow for hearing. Application, kal application heading আসবে. Serve a copy. Yes, next. Why?
Number 2.
Yes, what is, why is it appearing as to be mentioned?
My lord, I am for the appellant. I was directed to file a paper book within 4 weeks, that is within the 11th of March. My lord, I'm praying for your lordship's leave to file it today. I have served a copy.
Today, you are
Yes.
Learned counsel for the appellant seeks an extension of time to file paper books. Push up, such extension of is granted till today. Push up, the appellant shall file such paper books in the department during the course of the day, not here. Next. Can not here, কোন can not here? যেটা মেনশন করেছিল সেটা নেই?
My lord, I am appearing for respondent.
Miss-
But the
Yes.
copy not yet served.
Acha, that apart, where are the cans lying? You had mentioned.
Department was filed long back on where
Cans could not be traced out. You have to, Mr. Rokit, you have to find out where the cans are lying exactly, what department. Put it on a slip of paper and give it to our officer. We'll requisition it.
that's why my lord also directed
Yes.
that if it is not found in the
Yes.
department,
Yes.
I should start the Xerox copy of the all. See applicant.
It was not being placed for quite some time.
Yes. Can you look to this?
Acha, Mr. Rokit, do this. Since your learned friend is appearing, serve copies of all the applications on them. We'll keep it day after tomorrow for hearing of the applications, and we'll treat these two applications.
Here and now, which is an application process.
Mr. Rokit, please hand over copies of the applications. They have to go through the applications to prepare themselves. When you hand over, they'll prepare themselves. We'll keep it day after tomorrow and hear out the applications.
Because affidavit of service is there.
The learned counsel for the appellant is requested to serve copies of all the applications on his counterpart appearing for the respondent during the course of the day. Full stop. The matter shall be listed day after tomorrow for under the heading applications.
If I file the Xerox copy of that application.
We'll take it on record on the next day of those applications and treat it to be originals. They'll serve these copies today. 2 of the applications are missing. We'll treat their extra copies as you file 2 extra copies on the next day for us. We'll treat those to be originals and serve a copy today, please. All the applications. Yes. Second appeal application again.
Petitioner মানে application for registration.
Registration.
Copy has not been served.
Right. বুঝে গেছি? হ্যাঁ। 2006
Yes. Application was filed within time.
2016 থেকে ফার্স্ট অ্যাপিল আমাদের ডিটারমিনেশন সেকেন্ড অর্ডার ফর টেনের কোনো ইয়ে নেই where is the service
Well, I have not served the honestly also direct.
oh we thought you had served the appellant shall serve a copy of this application on the respondent indicating that the same shall be listed on April 21 2025 full stop. An affidavit of service shall be filed on the next returnable date by the appellant.
But can it be on 23rd?
তাহলে 23rd করে দিন ওটা returnable date 23rd you file an affidavit of service.
I appear to be apparent, madam.
Yes, Mr. Bose, what is the matter?
There's an application under section 5 and an.
You have served copies.
Yes, the state is appearing on a previous occasion, my lord. Learned advocate appeared and
You are directed to serve copies and file affidavit of service. What is that envelope?
is the envelope sent to the party. And my lord, I had sent it to my counterpart in the Bardwan court to show that. To
That
try
has
and
been
serve the
received.
Lawyer,
Huh.
he has said client is not contacting serve the client.
But the envelope shows left, so you have to serve properly.
But they are proceeding with the execution.
At the same, they have not changed the address in the code below.
And this is the advocate, this is the letter from the advocate who was lastly representing them, saying that we have no further instructions.
What is the decree?
This is a reference under section 18 of the Land Acquisition Act. I am the requiring body. There is a delay. Now, my lord, these all arise out of one single LA case. There are several reference cases. The other appeals, my lord, have been
admitted, I'll just hand up a copy of one such, all filed with delay. The delay could not be condoned because they came and said one of the respondents has died. So the substitution application had to be taken out and the heirs of the deceased respondent have been brought on record.
Now they are on record.
Now they are on record.
This application is only for stay.
There is one section 5 and one stay.
What is the delay?
I'll tell you, Lordship.
Which one is for delay? Can 1 and 2?
And one would be delay.
Application gulo kothay?
The old can
Page.
3447 would be delay.
3447 is 1. Yes, that is delay. Sorry, what was the period of delay you said, Mr. Bose?
Yes, my lord. I'll just tell you, Lordship.
582 days. What is the reason?
You're not even aware. State conducted the proceedings, forgot to tell us that they've suffered a decree in all of these cases.
It ran ex parte against you.
Yes. Requiring body reference case usually does not appear. This is also a parastatal agency. If it was a private.
But you were a party there.
Yes, yes. But all of these appeals filed with similar more or less delays.
The appellant, the learned counsel for the appellant files an affidavit of service which indicates that the intended service on the private respondent could not be affected in view of the envelope having returned with the endorsement left. However, learned counsel points out that the appellant, that the said respondent is proceeding with the execution case in connection with the impugned decree, which arises out of a reference case under Section 18 of the Land Acquisition Act. Next para, it is further submitted that there has been no change of address of the said respondent effected in the executing court. Next para, moreover, service was sought to be effected on the learned advocate for the said respondent in the court below, who intimated that he does not have any instruction to appear in the matter here, as well as does not have any contact with his client. A copy of the said letter is also handed over in court today. Both the affidavit of service and the said letter are kept on record. Since it is submitted that the private respondent is continuing with the execution case without any change of address, we deem that proper service have been sufficiently effected on the said respondent, and the said respondent is deliberately avoiding service. Next para, can 1 of 2016 within bracket old number can 3447 of 2016 is an application for condonation of delay in preferring the appeal. We find from the averments therein and from submission of learned counsel that the reason for the delay was that the appellant was initially not aware of the proceedings or the decree against it, and subsequently, upon coming to learn of the same, has preferred the appeal. Being satisfied of the sufficiency of the ground, can 1 of 2016 within bracket old number can 3447 of 2016 is allowed, thereby condoning the delay in preferring FAT 15 of 2016. Next para. The other can is for stay.
Yes. So we'll have to deposit the amount with interest.
Yes,
whatever.
yes. Can 2 of 2016 within bracket old number can 5426 of 5425 of 2016 is an application for stay of operation of as well as execution of the impugned award for enhancement of compensation under the Land Acquisition Act. Next para, being satisfied of the prima facie case, we grant stay of operation of the impugned award as well as stay of all further proceedings in money execution case number 17 of 2014 pending before which court, Mr.
Third court, Bard 1.
That was the that is the reference court, yes. Pending before the learned additional district judge, third court at Bard 1. What is the district now?
Paschim Bardhaman. Oh, no, this would be, yes, Paschim
I've
Bardhaman.
forgotten. District Paschim Bardhaman.
Because it relates to Asansol Durgapur area, so Paschim
In
Bardhaman.
connection with LA case number 22 of 2017 till disposal of the present application, subject to the appellant depositing the awarded amount with the learned registrar general of this court within what time would be this? within
weeks, my lord.
within 4 weeks from date. Full stop. In the event such deposit is not made within 4 weeks, comma, the stay order shall stand automatically vacated without further reference to the court. Full stop. There shall be unconditional stay till 4 weeks from date. Full stop. Next para. Thereafter, comma, upon the deposit being made, comma, the stay shall continue till disposal of the application. Full stop. Next para.
The disposal of the appeal, my lord.
Will this? Oh, you have served. হ্যাঁ তাহলে ঠিক আছে আমরা তো হোল্ডই করেছি স্যার তাহলে টিল ডিসপোজাল অফ দি অ্যাপিল দু জায়গায় অ্যাপ্লিকেশন বলেছি টিল ডিসপোজাল অফ দি অ্যাপিল দু জায়গাতে নেক্সট প্যারা upon such deposit being made comma the learned registrar general shall have the said amount invested in a short term interest bearing account with any nationalized bank and comma upon being approached by the parties comma furnish the particulars regarding such amount to the parties. We shall also pass the necessary directions for preparation.
Calling for the LC.
Very well. Put in postal requisites for service again because they have not appeared.
Special messenger, my lord, for the.
That also. Requisites and postal costs for service of notice on the appellants shall be deposited by the service of notice on the respondents shall be deposited within a fortnight from date. Full stop. The trial court records be brought by special messenger at the cost of the appellants, comma, appellant, comma, also to be deposited within a fortnight. So, next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop, liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. পশ্চিমে পুরো গুলি আসানসোলটা কি আছে পশ্চিম হচ্ছে
My lord.
আড্ডায় ছিল
My lord,
ঠিক আছে জানি
may I be permitted to give one indulgence, my lord? In 82, I was allowed to file the paper book by
Okay.
the course of today. My lord, did my lord fix any order date for hearing? My lord, kindly fix.
we are not doing that deliberately we cannot add matters unless some of the appeals are
But
your senior sent you back again tell him that we are not including yes
this is my application for
Mr. Yes.
restoration, right? In the
Dismiss at
in
the
admission stage, it was
admission.
dismissed for default.
You have to
yet
serve a
been
copy and
admitted.
come back
But there is no caveat since we have not served. The appeal has not yet been admitted, but in order for to stage, it was dismissed.
even then serve a copy and come back so that will take care of the service of notice of appeal also.
My submission is if your lordship kindly allow my application and keep it for order 41.
Achha, restoration they
it
were
was
also
the-
not present
No, there was no caveat in the admission.
there was no
stage.
caveat.
In the order 41 stage, it was dismissed. So, service of any
This
notice.
can which one item 6 can 1 of 2018 or can 2 must be can 1 must have been the stay you could not have anticipated that they would be
Subsequent event. Two it will be. And that matter order,
very well.
and this is within time, my lord.
What is the reason given Mr. De just for the records
Page 7 and 8, my lord. This is the usual stand we take, my lord. In case the other code and clerk miss the list.
Well, the application has a can 2 of 2019 within bracket old number can 12543 of 2019 bracket close is an application for restoration of the appeal which was dismissed at the admission stage by a coordinate bench. Oh no, Mr. De Justice Bhattacharya is still there
Shambhuddha Chakraborty.
and Justice Hiranmaya Bhattacharya.
Single bench, my lord. That is why, my lord. we have
No,
not-
no, no,
But your lordship has the determination.
no. Restoration, restoration. Very well. Continue করে জানাবো. By a coordinate bench, full stop next para. Since on the day of the dismissal, none had appeared for the respondent as well, comma, and there is no caveat, comma, we treat the scenario to be one under Order 9, Rule 4 of the Code of Civil Procedure and take up the application for hearing ex parte, full stop, being satisfied with the reasons for the absence of the appellant on the relevant date, comma, can 2 of 2019, old number can 12543 of 2019 is allowed, thereby recalling the order dated December 3, 2019 and restoring SAT 156 of 2017 to its original file and number. Full stop. Let the appeal along with the connected pending application be listed for hearing tomorrow under the heading
No,
order.
tomorrow, but this is a very
No, that's the cost for
Difficult
restoration.
matter, Lordship. Kindly, I want to make next Monday, Lordship, kindly give it on next Monday. I have to make myself ready, my lord.
Be listed,
This is a very complicated case,
very.
very complicated.
be listed another order 41 rule 11 on April 7, 2025.
Good, good.
Complicated মানে কিছু নেই, মানে কিছু নেই, এর কিছু নেই, that's all.
Very complicated. In this matter, my lord, I beg to appear on behalf of the respondent, plaintiff respondent, my lord.
It's your application,
My lord, no, my lord.
their application.
Their application, my lord, possibly application has not been served, but I think that this is an application for restoration. But they are not appearing and taking advantage of the pendency of the matter. They are making.
But this restoration is appearing for the first time here.
No, my lord, kindly cease, my lord, solemn order dated 18th December 2020.
No, the restoration application is appearing, it has been appearing before us also.
Not before my lord justice standard and my lord justice Mudur responsible. 18th December 2023. Your lordship will kindly see. They are not appearing. So, my lord, why I beseech your lordship to direct me to serve a notice upon the learned advocate and my lord let it appear any day, my lord. In course of my lord, today some his work maybe there is a meeting going on, my lord.
We
So,
devise we devise his works.
No,
Matter.
my lord. What?
No, but we don't.
I
we
will.
don't.
I will have to
In
serve.
contested matters, we don't take up expertise.
I will
But in
have to
matters
serve.
where there is no contest or both sides are there, we take
My
up.
predicament is this: I have to serve the notice upon the landed advocate
How
of
soon
the.
can you do that?
But in course of today, I will try. If
We'll
he is
keep it day
present.
after tomorrow.
Day after tomorrow. I bow down to your lordship. I am extremely grateful.
None appears for the appellant stroke petitioners at the time of call. Full stop. Next para. Learned counsel appearing for the respondent submits that the appellants have been consistently absent at the time of call before different benches. Full stop. Next para. Accordingly, on the prayer of the learned advocate for the respondents, the said learned advocate is requested to serve a notice on his counterpart appearing for the appellants, indicating that the applications shall next be listed on April 3, 2025. We'll keep it next Monday because Thursday we take up hearing matters. On April 7, 2025, under the same heading.
Bow down to your lordship.
The learned advocate for the respondent shall file the receipt in that regard on the next returnable date.
I bow down to
No, I am for that.
Yes.
Section 5 application, affidavit of service is not completed.
Not complete. Complete হয়নি বলছে। Since learned counsel for the appellant submits that the service is not yet complete, let the matter stand adjourned till us when?
Please do. 8 million.
Till April 8, 2025.
For the respondent, but here the probate application was not dismissed. Not holding that PW3, one of the attesting witness, not on the witness box in cross-examination.
But unless they move the matter.
That's why, Milord, 2017, Milord, the matter was, Milord, non-being moved. My learned senior friend, Milord, upon notice, Milord, have mentioned the matter. Your lordship again direct me, Milord, to serve, so that if they are wish, Milord, to proceed with the appeal. Otherwise, Milord, the matter is kept pending, Milord, for which, Milord, they have illegally recorded his, Milord, name. Milord, though the probate application.
None appears for the appellants at the time of call. Full stop. Learned counsel appearing for the respondents files an affidavit of service indicating that a notice of mentioning with regard to the applications for inclusion in the list has already been served on the appellant, but the appellants still choose to remain unrepresented. Full stop. Next para. As a last chance to the appellants to appear and move their applications, the same is adjourned till April 7, 2025. Full stop. The learned advocate for the respondents shall serve a further notice indicating the returnable date on the learned advocate for the appellants. Full stop. A receipt in that regard shall be filed on the returnable date. Full stop. It is made clear that in the event the appellants remain unrepresented on the next date, appropriate ex parte orders may be passed in their absence.
7 and 8, Milord, due to Annapurna.
9th. Returnable date 7 না করে 9th.
Great.
Alimony.
My lord. My lord, affidavit of asset, my lord, is to be filed, my lord.
The alimony application is styled as appropriate direction. This is that application.
No, application for,
Oh no, that is different.
that is their opposition.
Acha, very well. Can 2 is the alimony application. Let us find out the pleadings first. So your application, affidavit of asset. Mr. Bhattacharya, when you file affidavit of assets in the back sheet, just write affidavit of assets for the wife, like they have done. It's easier for us to find. They have done it. So this is their opposition and affidavit of asset. What about your reply? No reply? Need not.
I will proceed on the basis of Milord.
Very well. একটা অর্ডার রেকর্ড করেন প্রথমে যে affidavit in opposition and affidavit of assets of the appellant husband filed today be kept on record for learned counsel for the respondent wife stroke applicant submits that in view of the averments made by the husband, comma, no further reply is required to be filed. Accordingly, we take up the application without any reply from the wife. Yes. He has to move, so
Yes.
yes. Take your seat, Mr. Manager.
Yes.
Just
Milord, kindly takes up Milord can 2. This is my application. Milord, kindly comes to the prayer at page 9. This is my ultimate prayer.
yes.
Well,
Yes. No, you are for the. You are appearing with him.
Joint meeting has been held at the Bar Library as well as Bar Association.
Yes.
My lord, we have taken a decision to mock protest. My lord, we will not participate in today's judicial proceeding to protest that proposed transfer.
Will not pass any adverse order if there is any.
I leave it to your lordship.
No, we are telling you, we are making it
Alright.
clear so that there is no misunderstanding with the bar.
Great.
Sometimes there is, we don't want that. If in some matter both sides are appearing, but one of them is not there, we shall not pass adverse orders. If it's an ex parte scenario like an order for 10 will 11 without a caveat, we'll take up if the appellant moves. Otherwise, we won't. I mean, yes. Yes.
This is Milord, my prayer. Milord, kindly see Milord 35,000 per month.
35,000 per month. Any issue of the marriage?
Yes, son. 25,000 Milord for the
Age of the son, Mr. What is the approximate?
reading in class 8. Milord, reading in class 8.
Class in me about 14.
14.
Yes.
Now, Milord, now,
You don't do anything according to you. What does he do?
Milord, from the affidavit of assets, we understand that he has a business of his own.
Any income disclosed by them?
Yes, in LLP, I'll come to that, Milord. Before that, Milord, kindly takes up, Milord, what are my averments and requirements, Milord. Kindly comes, Milord, from
Application or affidavit? Of
application. Milord, kindly comes to Milord page 4, Milord.
Para 13.
Page 4,
Oh,
Milord, para
not
6. Onwards, Milord, petitioner is was at that point of time when it was, Milord, filed 6. Milord, the tuition fee, Milord, was 6.
You have given a breakup of the son at para 13.
Para 13, Milord. Yes, that is apart from Milord educational expenses, Milord, this Milord requirement. These are the requirements.
Annual tuition fee 66,500. What does it come to per month?
No, it's quarterly, Milord, quarterly.
We will
Milord
make a
annual.
monthly calculation
12 months ভাগ করো।
because we have to pass monthly alimony order.
রিসেন্ট যেটা হচ্ছে ক্লাস 8 এর হচ্ছে অ্যাডমিশন ফিস দিয়েছে
65,000.
Total
5,500 probably.
total is Milord 94,600.
What 94,000?
For that is Milord the
Annual fees 66.
not a part of it record because this has been Milord
It's beyond your pleadings then.
no, this is Milord for class 8, Milord.
No, you cannot file something which is not in your affidavit of asset.
Subsequent, Milord, this
You
is
cannot look into this. They are not prepared with this.
Milord, 66,500 by 12 crore.
That comes to about 5.5 thousand per month.
Yes.
And what about the other 10,000 per month?
Yes. And
Drawing
Milord,
teacher. Acha, very well. What sort of extracurricular?
Milord,
Different.
extracurricular, Milord, I have given Milord
Private
kindly
tutor,
comes
tiffin.
to
Pool car, very well. A drawing teacher, yes.
Yes.
Well, legitimate more or less. So 15,500 per month is your requirement for the son.
And Milord, for
Approximate.
myself,
Your-
Milord, yes. And another thing, Milord, kindly comes to Milord, the page 18 onwards.
Multivitamin protein.
For the son, Milord, he was Milord admitted there, and he had a Milord long treatment. Milord, he had to be continuously Milord administered these medicines. Milord, and the father did not even care Milord for once to Milord go and meet the child and to bear the expenses.
Can appreciate that, but these are general medicines.
Medicines, but
Azithrol, Calpol,
Milord,
even we know that these are
expenses for expenses.
minimal expenses. That
Expenses,
comes
yes.
within regular
Yes.
expenses. What are your breakup? Where is your breakup?
Milord, my breakup, Milord, as if
Not
Milord,
given anywhere.
uh,
So you have put in a total requirement of 35,000 per month.
35,000, Milord,
So we take it that your requirement has to be 20,000 then, 15,500 for the son and you.
20,000.
That is a composite requirement. But total amount claimed is 35,000.
No, 25 and 35. Kindly see page 9.
Oh, 25 is not. Oh, acha. Oh, sorry. We thought it was litigation. 35,000. Why?
Because two things, Milord. One, Milord, we have to my husband, the wife and the son reside in a flat which is owned by the husband. We have to Milord pay electricity bills. Now, Milord, the Milord, again a very recent Milord development. We could not Milord since the pleadings are complete, Milord, we could not Milord annex it. The Secretary of the Housing Society has Milord given put a notice in the notice board that from 2020 up to Milord 2023, Milord, the maintenance charges were paid. Milord, thereafter, Milord, maintenance charges were not paid. Wife has cleared a portion of it.
Yes, but what is the? Must have shown that in your affidavit of
No,
assets.
can't be because this is a recent Milord development.
This is recent, but till 2023 you have been paying maintenance charges.
Not the husband was paying. Husband was paying.
So
Husband was
previously should have asked for opportunity to use these. Otherwise, how can I look into
paying.
this?
I have disclosed
If
this.
your affidavit assets shows electricity charges, bills are annexed.
Yes, Milord.
Approximately, what
Page
is the
40,
expense?
Page 39 and 40.
What is the approximate electricity charges per month?
145 per unit, that comes to
Electricity.
6330. And this is notice of disconnection. At one point of time, Milord, the wife could not
What is the average of these? Because most of these are illegible. We can't.
No, kindly see, this is page 39 on the middle. This is Milord, the notice of disconnection. Milord, average, since the wife could not pay at one point of time, Milord, husband stopped giving. Milord, notice of disconnection, a total comes 6330. This is not monthly. This is not monthly. This was area due.
Why 35,000? 35 is exorbitant.
Milord, that I leave it.
What is
to
the
your
income
lordship.
of the husband as per his?
Yes, 75,000. Milord, what they have
75,000.
disclosed. In their affidavit of assets, Milord, page 4, Milord. Page 2, the serial number clause 2, they have disclosed 75,000, Milord. And I'll show from the Milord judgment of Rajnesh versus Neva, this is gross suppression.
Why do you say that?
Yes.
How do you know that?
Now, Milord, kindly see, Milord, kindly excuse me, there is more than 100-page judgment. I could not, Milord, take a print out of this. But kindly see, Milord, read. If
So read to us from that.
Yes, very good. Kindly see, Milord, the F, clause F at page, Milord,
Rajnish versus Neva forgot 2021.
2021.
Give us a total citation.
2021 to 324.
2021, volume 2 SCC 324.
And this is clause F of which para?
Clause F, Milord,
Non-agrarian.
of enclosure 1 of non-agricultural,
That.
non-agrarian deponent. Kindly see, Milord,
Yes.
F. Kindly see what are the particulars. Kindly see, Milord, what are the Milord particulars, Milord, which are to be given for non-agrarian deposit. F. Name of the employer, designation, monthly income. They have disclosed monthly income. If engaged in a government service, this is not applicable.
Does business.
Business.
How can there be a name of employer and
Yes. Kindly comes to
come from other sources?
7, 8, and 9.
Yes.
Kindly comes to Milord 7.
IT returns have not been filed.
No, not at all. 8, Milord, kindly see, Milord, the income from other sources, Milord, he has given, Milord, certain, Milord, names of, Milord, logistics firms, mutual fund, but no particulars. 9, furnish copy of the bank statements of all accounts of 3 years. Milord, that is also not been done. 1. Number 2, Milord, kindly, if your lordship kindly comes to next, Milord. I.
Yes.
Milord, kindly comes to uh, Milord, description of business, Milord, kindly comes to 7. 7. In case of self-employed individual, provide the filings of last income tax return from any such professional business or vocational activity. Milord, this is also not given. Therefore, clear, Milord, suppression. They have only stated, Milord, 75,000, and they have, Milord, given, Milord, the bank the name of the bank accounts, Milord.
Bank statement has not been given.
No IT return, no bank statement. Even the IT return of his business, that has also
No
not
IT
been
return at all.
Not at all. At least, Milord, the amended copy which has been served upon me, Milord.
What business does he do? Has he disclosed?
Yes, Milord.
Nature of business?
Nature of business, Milord. Yes. Milord, page 10. Page 10, Milord, logistic business. I am responsible for overall business functioning, including fund arrangement, sales and revenue generation, operational efficiency, compliance, borrowings and repayment to financiers, team building, and solely accountable for profit and loss of LLP. Well, this is what they have stated. Now, Milord, kindly comes to my affidavit of assets. Milord, kindly see, Milord, I have given, Milord, I do not have ITR. No question of giving, Milord, return. And Milord, we have given, Milord, bank account statements of the last 3 years. From where it will appear, Milord, husband has been intermittently sometimes paying 2,500, 4,000, 6,000.
It's an ownership flat where you are residing.
No, this is flat is in the name of the husband.
Ownership flat, not a rental.
No, ownership flat, Milord, but it is under hypothecation. And this is what?
Let us hear. Yes.
The difficulty, my lord, is, my lord, that the income tax return, my lord, is of the company. The company, my lord, is a private limited company, my lord. The income tax return is, my lord, it's an LLP, my lord. The company, my lord, regularly pays the income tax, my lord. Husband, my lord, if the IT return is to be, my lord, annexed, it has to be annexed, my lord, of the LLP, my lord.
Why didn't you annex it?
The LLP.
You are the sole owner of that LLP. How can it be? You have said it's your business. Then it cannot be LLP.
My lord, kindly, my lord, I've taken the amendment, my lord. My lord, kindly comes to, my lord, page 10. Page 10, my lord, I1. But kindly sees, my lord, the last line, my lord. Team building, solely accountable for profit and loss of the LLP.
In I, you have stated before I1, business within bracket entrepreneur of MSME. So you are the sole entrepreneur. It's your business. How can it be an LLP then? These are contradictory.
But he's a partner, my lord. I'm taking.
Then you cannot say business entrepreneur. If you're an entrepreneur, it has to be sole proprietorship. And if it's a partnership LLP, who are the other partners? Where are the particulars of the other partners? You have to give particulars of the applicant's share in the partnership. That's 2. You have quoted that also. C2, item 2. And that's very specific. You have quoted that. Whether the business is carried on as an individual sole proprietorship, partnership comes as LLP. You say LLP and then give particulars of the applicant's share in the partnership. Not that the deed has to be given. So it's gross suppression.
But my lord, kindly, my lord, takes a, my lord, 3, my lord. 3, my lord, on my side, my lord, I'll say, my lord, that the...
You have just said it. Nothing to support it. Sorry. Nothing, no paper at all. Total loan outstanding amount. No papers to support your... You don't have any personal income tax return.
I'm talking on, my lord, I'm saying on this on instruction.
We'll refer it to the income tax authorities immediately. You are running an LLP. You are a partner in an LLP. You don't have an individual income IT return. We'll actually refer you to the IT authorities. There's nothing to prevent us from doing that. And we'll ask him to to ask the authorities to act on his communication. It's gross suppression. We'll take adverse inference against you and grant full alimony as paid for the payer.
My lord, kindly
Full
consider,
alimony.
kindly considers this aspect.
Whatever
my
they
lord.
prayed.
My lord, kindly consider this aspect. My lord, this part has been, my lord, not happily drafted. My lord.
No IT returns. None of your IT returns, LLP IT returns. Where are the bank statements of the LLP and you? Nothing has been given. And you have been deficient on several aspects. We remember this matter. We have given time on other occasions also for other reasons.
Yes, my lord. This was
You have
my
been
lord,
deficient. You
affirmed,
paid
my lord.
costs probably also for related filing.
Yes.
Till now, we are not ready. We'll dispose of the application, grant full alimony, whatever they have asked for. 35,000 they have asked, we'll grant her 35,000. Son, yes, we are not satisfied with 25,000. But yes, educational expenses and school expenses alone 15,500. So he's a human being. He must has his own requirements also. A boy of about 14 has his own requirements. And life is just starting for him. And I mean, you are running an LLP? Yes, absolutely. Why not 25,000? 10,000 more only per month for him, for his other expenses. So 25 and 25. 35 and 25. It comes to 50. 60, sorry, 60. Pay him 60. Pay her 60.
My lord, kindly consider.
We'll draw adverse inference right now.
But only one, my lord, part. My lord, on the last occasion, my lord had refused to, my lord, accept, my lord, his my lord, affidavit, my lord, since it was not properly affirmed. My lord, this now the current affidavit has been
No, we'll accept this affidavit and proceed on this.
because there is suppression, my lord, in this affidavit also. My lord, in the last affidavit there was much more disclosure.
Heard learned counsel for the parties on the alimony application of the respondent wife. Push up next para. The case of the respondent wife is that she is unemployed and the parties have a son who is living with the respondent wife. Push up, the son studies in class 8 of a school and is of about 14 years of age. Push up, the particulars disclosed regarding the educational expenses of the son apparently come to about rupees 15,500 per month. First up, the amount claimed for the son in the application is 25,000 per month. First up, we are of the opinion that 10,000 per month over and above mere educational expenses is quite reasonable for an adolescent who is just starting his life and has other requirements, going by the proverb, man does not live by bread alone. Full stop, next para. Learned counsel for the wife also submits that the wife requires rupees 35,000 per month for her upkeep. Full stop, it is submitted that although recent development, some of the documents regarding such requirement, arising out of recent developments could not be annexed to the affidavit, it is a fact that since the wife and the son are residing at a residential accommodation, which is an ownership flat of the husband, and the husband has stopped paying maintenance charges since 2023, and the property is under hypothecation, such residence is also precarious for the wife and the son. Full stop. It is submitted that recently a notice has been given to the effect that around rupees 6,330 is due in lieu of maintenance for the housing society. Full stop, next para. However, there is no such document on record before us. Full stop, be that as it may, we find from the affidavit in asset of the husband that the same is squarely in contravention of the decision in the matter of Rajneesh versus Neha, reported at 2021 2 SCC 324. Full stop. Despite having been given several opportunities, the husband filed the affidavit late and paid costs as per our direction on such count. Full stop. Even today, when the affidavit of asset is filed, we see that neither the income tax returns of the husband for the relevant period or otherwise has been disclosed therein, nor has the tax returns of the limited liability partnership capse within bracket LLP bracket close run by the husband being furnished. Full stop. More importantly, comma, the bank statements of either the husband himself or the LLP have also been suppressed totally. Full stop. The husband claims to be in a logistic business, and it can very well be assumed that the suppression as indicated above is merely to hush up the actual income of the husband and the limited liability partnership run by him. Full stop. Next para. Thus, comma, we draw adverse inference against the husband on such count. Full stop. In view of the suppression of his income by the husband and taking into account the requirements of the wife and the son, comma, we are of the opinion that the amount of alimony claimed in the application is quite reasonable. Full stop. The amount claimed in the application is rupees 35,000 per month for the wife and rupees 25,000 per month for the son, comma, bringing it to the total of rupees 60,000 per month. Full stop. The wife has also claimed rupees 1 lakh as litigation cost. Full stop. However, comma, regarding litigation cost, comma, for the present, comma, we are of the opinion that rupees 50,000 would suffice, keeping in view the litigation expenses in our state. Full stop. Next para. Accordingly, can 2 of 2023 is partially allowed on contest, comma, thereby directing the appellant husband to pay alimony at the rate of rupees 60,000 per month to the respondent wife for herself and her son. Full stop. Litigation costs of rupees 50,000 for the present shall also be paid as a one-time payment to the respondent wife by the appellant husband. Full stop. Next para. The said the litigation, the alimony shall be paid from the date of filing of the application. Full stop. The current alimony shall be paid by the 15th day of each current month, comma, starting from April 2025. Full stop. Next para. Insofar as the arrears of alimony from the month of filing of the application till March 2025 is concerned, comma, the same shall be paid by 3 equal monthly installments, comma, payable by the end of each month. Full stop. The first such installment shall be paid by April 30, 2025 and thereafter by the end of each of the succeeding months. Full stop. The litigation costs shall also be paid by April 30, 2025. Full stop. All the above payments shall be made directly to the bank account of the wife by online transfer. Full stop. The particulars of such bank account shall be disclosed by the learned advocate of the wife in writing to his counterpart appearing for the appellant husband by tomorrow. Particulars of the bank account? By April 4, 2025. Full stop. Next para. It is made clear that it is his appeal, your appeal. It is made clear that in the event of non-payment of any of the above accounts, comma, the respondent wife shall be entitled to ask for appropriate orders in respect of the appeal as well as for implementation of the said order. No address to cost.
Sir, on the last occasion, my lord, there was a direction from your lordship, my lord, to inquire from them, my lord, whether they are, my lord, subject to payment of this amount, my lord, whether, my lord, they are, my lord, interested in mediation. On the last occasion, my senior friend, my lord, intimated that, my lord, they are interested, my lord, subject to the payment.
Make the payments. It will be subject to them. At the line at Kodin, it is made clear that nothing in this order shall prevent the parties from settling the matter between themselves or to seek mediation, comma, if both the parties agree on such count, full stop, and we'll direct you to put in the special messenger costs and all. In view of the appearance of the respondent through her learned advocate, comma, service of notice of the appeal on the respondent is dispensed with, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention for inclusion in the list as and when the appeal is ready for hearing. You earn much more. That's why you have not disclosed. This is not also not too much.
Or I cannot, my lord, improve on the draft, my lord. I apologize, my lord.
Could have asked for more, Mr. Bhattacharya. Anyway, with this money, engage private detectives so that you can get out his actual income. You can ask for enhancement. He surely is earning much more.
Definitely, my lord, my client for the first time came to know, my lord, from his affidavit of assets, there was a previous marriage and a son from the previous marriage. Lord,
Anyway, that also entails further expenses for him. So that will be his liability also.
that's why, my lord, my client also wants, my lord, now.
For the time being, whatever you are getting, that's what.
Well, for the time, my lord, kindly, my lord, refers it to the mediation, my lord. Otherwise, the payment would be made, my lord, otherwise that fails.
Full arrears have to be paid, litigation costs have to be paid, and till full arrears are paid, the current monthly alimony for that period has to be paid. Only then come back. If this bench is there, don't come back before that. So other bench is there, take a chance.
This matter, I am appealing for the appellant White.
Yes.
Something unfortunate is there. But your lordship will kindly look at the order dated 3rd of October 2024. Not the learned advocate for the husband, respondent husband, she never appeared. A few occasions he appeared, despite repeated notices from this court, my lord, he was not there. My lord, prior thereto, my lord, by an order dated 12th September 2024 also, my lord, I was directed to communicate this order to the learned advocate. That day also she did not appear. On the second day, 3rd of October, they did not appear. Today also,
They have never appeared. We don't see their
at
appearance.
times, my lord, to be
Previously, they had appeared.
to be very honest with your lordship, my lord, for the purpose of ensuring his appearance, my lord, the local police station was directed by the coordinate bench presided by Justice Somin Sen. And only at the intervention of the police, the husband appeared. Affidavit of assets have been filed by both the parties. Now, my lord, this matter was heard in length, but I must submit before your lordship. The matter was heard in length in presence of the learned advocate before the bench presided by my lord Justice Tandem sitting with Justice Prashad. Now, my lord, there, my lord, two options were given to the husband. One is either pay a permanent alimony of 15 lakhs, because my application is under section 24 of the Act in connection with the appeal.
It's their appeal, your appeal.
My appeal is my appeal. My lord, I lost the suit.
Divorce was refused.
Yes, divorce was there.
So if you get 15 lakh as a lump sum amount, you are willing to part with.
Yes.
Achha.
And
What was the other option?
alternative was, to that, of course, they said, no, we are not in a position. Then lastly, the Honorable Court came down to 12 lakhs. But this was the proposal given to them. Other alternative, from the date of decree, till the date of decree, there was an order for alimony of rupees 5,000 per month. The day decree was passed against me, he stopped the alimony. The court said, well, you from that date till now, you pay 5,000 each month, whatever the total will come, and they 10,000 rupees per month as alimony, as spread for in the section 24 application.
You have asked for 10,000 per month.
I have asked for 10,000 per month. But these two options were given to them.
Did they pay anything to you?
Not at all. Even, my lord, I tell you, lordship, this is the two-story building owned by my husband. My lord, I used to live below the stair, in a thatched structure below the stair. By intervention of the court, my lord, one room in the ground floor was given to me together with a kitchen. I am living there. And my lord, I am also an old lady of 65, 66, like that. My lord, I do not have any income. My lord, that way, from that observation of this honorable court, the husband is not appearing. My lord, I do not know what.
They have an additional option today, the third option, which is the strike called by you. So they'll take that ground also.
Of course, sir. Of course.
We'll do this. We'll request you to give another notice to their advocate, indicating that if they don't come, then we'll take up this application expertly and dispose it. For the time being that, and thereafter, because if it was their appeal, we could have dismissed on the next date. But your appeal, obviously, we won't dismiss, and we cannot close arguments.
But I am happy either with the permanent alimony or the manner the court had felt. But either of the way,
They are obviously not happy with that.
Of course.
So we'll have to decide this application whichever way. And then if you levy execution, probably then we have a handle to actually ask the police to do whatever.
My lord, the On twice, my lord, police was directed, bank was
For
directed.
hearing, we cannot compel
Yes,
them.
yes,
Under
yes.
the law,
No,
we
no,
have
no.
our reservations on
No,
that.
let there be another notice.
They have an
my lord.
option not to appear.
Kindly keep
And
it for the next week, my lord, I shall serve the
we
notice tomorrow.
will keep it on next Tuesday so that you get one additional day Monday.
Yes, yes, yes.
Very good. None appears for the respondent stroke husband at the time of call. Push up. The present application is one for alimony filed by the appellant wife. Push up. Learned counsel for the appellant by referring to the previous orders passed by different coordinate benches in this matter, points out that the respondent husband is consistently unrepresented at the time of call. Push up. It is submitted that two options were given on the last occasion to the respondent husband by the bench taking up the matter, one of which was payment of a lump sum amount of permanent alimony to the tune of rupees 15 lakh, the other being to clear off the entire alimony at the rate of rupees 5,000 from the date of the impugned decree till date, as well as payment of current alimony at the rate of rupees 10,000 as claimed in the application. Push up. However, till date, no response has been given by the respondent husband to either of the two options, nor has any amount been paid by way of alimony. Push up. Next para. We find from the records that there is substance in the contention of the appellant. Push up. However, as a last chance to the respondent husband to appear and contest the alimony application, we request the learned advocate for the appellant to serve a notice indicating that the alimony application shall be listed next on April 8, 2025 under the same heading. Push up. A receipt in that regard shall be filed by the learned advocate for the appellant on the returnable date. Push up. It is made abundantly clear that in the event the respondent remains unrepresented or seeks adjournment on the next occasion, the court may dispose of the alimony application ex parte uh, without hearing the respondent husband. You better take out a server copy of this order. It will be this evening. It will be uploaded, and with that you just.
The only thing that should I serve the learned advocate? I understand that the learned advocate who was appearing, Mr. Gorachand Samanto, but he is,
Achha.
perhaps he is not keeping in touch with that advocate.
Very
To
well.
be served both on the husband and the advocate.
তাহলে একটা যেখানে বললাম application notice shall be served, request the advocate for the appellant to serve a notice on the learned advocate for the appellant respondent as well as the respondent himself. আর তাহলে next returnable date যেটা ওই receipt in that regard বললাম, affidavit in serve of serve, because you have to serve them all.
Of course.
So can you come up so soon or should you keep it the next week after
No,
that?
my lord, I shall do it right today. No, the matter is long pending. My lord.
Very
I'm great.
8. Not today, yes. Same, not today.
My application, there is an application for the
Appearing for the first time?
well, second time because
No, you have served on the other side.
no, my lord. Earlier occasion we found there is a delay to filing on appeal, my lord. There is a delay of 145 days.
So this is that section 5 application?
Yes, my lord. My lord, kindly direct me to serve.
We'll direct you to serve copies of both the other application has been served.
Yes, my lord, they has to be served.
We'll direct you to serve.
My lord, kindly direct
Yes.
me to serve.
The appellant shall serve copies of can 1 of 2024 as well as can 2 of 2025 on the respondent, indicating that the applications shall be listed under the same heading on April 22, 2025.
Instead of 20, my lord, can it be the my lord, 10th? Because my lord, 19 is a date fixed for the domestic violence case in the learned court.
There will be 16th. April 16th, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Obligation.
Thank you.
But I'm being led by Mr. Probal Mukherjee.
Yes,
Being led by Mr. Probal Mukherjee, my lord, is not appearing today.
not
Kindly-
today. আজকে কোনো মানে
Kindly
not
keep the matter tomorrow. my
only not today. Not today means tomorrow. Oh, yes.
On the applicant. On the last
Anybody is appearing on the other side?
last time it appeared, your lordship was pleased to direct to serve all the copies, disposed of and
Today
pending.
there is a strike
I have
called
a-
by you.
yes,
Yes.
sir.
If they don't appear, we are not disposing.
Only one of the affidavit of service. sir.
The affidavit of service filed by the appellant today be kept on record. What a name. Full stop. Since none appears for the respondents, comma, the matter is adjourned for the day. Tomorrow, if they don't appear, they move the matter. Please give the all the appearances, whoever is there.
Appealing for the appellant. But a suit for grant of probate has been decreed by
Appearing for the first time.
appealing for the first time.
Stay of probate has been granted.
Probate has been granted.
We grant injunctions, not stay.
Well, that is my application for injunction.
There is no caveat.
There is no case.
অ্যাপ্লিকেশনের দিন না অ্যাপ্লিকেশনটা উপরে একটু দিয়ে দিতে হবে অ্যাপ্লিকেশনটা উপরে
That during
Basically-
pendency of the appeal, my lord, the
the
assets-
present appeal arises out of the refusal of grant of probate. For sub next para, we find that there is sufficient prima facie case as well as the balance of convenience and inconvenience and irretrievable injury factors operate in favor of grant of injunction. Full stop. Accordingly, the respondent or respondent
the respondent, sole respondent son.
accordingly, the respondent shall remain restrained by an order of injunction from selling, transferring, alienating, dealing with, and or creating any third-party interest in respect of the subject property covered by the disputed will till disposal of the injunction application. Full stop. The appellant shall serve a copy of the application on the respondent, indicating that the application shall be listed next on April 22, 2025, when an affidavit of service to that effect shall be filed by the applicant. Thank you.
I'm for the appellant petition, lordship.
For the first time, or there is somebody? First time. What is
My lord, upon the date of the respondent number,
application filed within time?
lordship. Lordship, after filing of the appeal, my lord, this application has been filed, my lord.
Yes, but when did the death occur?
Date occurred on, my lord, 5th of January 2025.
2025.
Lordship,
That is can 2.
lordship, can.
Within time allow করে দিয়েছে রেজিস্টারে allow করতে পারে হ্যাঁ আমি করে দিচ্ছি এখানে এসছে ফর্মে আছে কিনা একবার যাচ্ছি না আমি just the present application is for substitution of the heirs and legal representatives of the deceased respondent number 1, namely Shamul Kumar Pal, on his demise during pendency of the appeal. Full stop. We find that the application is in time and otherwise in form. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent number 1, Shamul Kumar Pal, comma, as disclosed in paragraph number 2 of the application, comma, to be substituted in place and stead of the said deceased as respondent numbers 1 small a and 1 small b in the appeal. Full stop. The necessary consequential amendments to the cause title of the memorandum of appeal and can 1 of 2023 shall be carried out by the learned advocate on record for the appellants during the course of the day. During the course of the day. Full stop. Injunction you have not yet served. What is the injunction application against? There was no caveat, obviously.
Lordship, partition suit was filed, which was, lordship, dismissed. Thereafter, my lord, this application has been.
We will direct you to serve copy of that also. Can 1 of 2023 is an application for injunction filed in connection with the appeal, comma, which arises against the dismissal of a partition suit. Full stop. Since questions of both fact and law are involved in the appeal, comma, we find that a prima facie case has been made out for hearing of the appeal on merits. full stop, also, comma, in view of the averments made in the injunction application, comma, there is sufficient, the balance of convenience and inconvenience and irreparable injury factors lie in favor of grant of injunction. Full stop. Hence, the respondents are restrained by an order of injunction. Possession, we are not sure about who is in possession. Regarding transfer, will grant. You have asked for possession only. Where do we, no, transfer also. Acha, very well. Restraining the respondents from transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the application. Full stop. The both parties shall maintain status quo with regard to the possession in respect of the property, comma, also till disposal of the application. Full stop. The appellants shall serve copies of this application on copies of Can 1 of 2023 on the respondents, indicating that the same shall be listed next under the same heading on April 28, 2025, when an application, an affidavit of service to that effect shall be filed by the appellants. Regarding possession status quo, injunction regarding the other aspect. But carry out the corrections, please, during the course of the day. Whoever is the advocate.
Shanali is there.
Ask him to do it today. Yes.
Because if there are 3 other connecting matters.
Is anybody appearing for the other side? Let us come back tomorrow.
Yes, yes. Not only thing, 3 other files are required to be brought along with this.
Why?
But there were 3 analogous suits.
Appeals from those.
Appeals from
If you furnish the numbers, will direct
Yes.
that, then they'll appear next week because it will take some time to bring. Very. Learned counsel for the appellants. You are for the appellants.
Yes.
Learned counsel for the appellant submits that certain other connected appeals arising out of decrees passed in analogous suits.
No, no, my lord. These are rejection of counterclaim under Order 7, Rule 11.
Arising out of the same suit.
Arising out of 3 different suits which were being heard analogously.
Acha, thale appeals arising out of 3 different suits which were being heard analogously. And as such, the appeals should be heard together.
But that can be said after the records come before your lordship.
No, otherwise we won't direct the records to come. There would not be any justification.
These were being taken up together by the other bench of this court, but thereafter.
Why were they separated?
Unfortunately, they were separated.
Then we have to be satisfied that they have
But
to
we
appear.
mentioned all the matters together.
That is no justification. We have to be satisfied that
There is an order of analogous hearing of all the 3 matters.
there's an order of court.
Yes, of the trial court. No, not of this court, but the trial court. The trial court was taking
The
up.
suits, the 3, how many suits are there? 3. 3 suits were heard analogously. These arise from different decrees or deemed decrees from those 3 suits.
Those 3 suits.
You are saying that only?
Yes. In one, counterclaim was rejected. In 2,
whatever.
Order 7, Rule 11 allowed.
Since learned counsel for the appellant submits that certain other appeals are pending which arise out of different suits which are heard analogously by the learned trial court, comma, we direct the said appeals and applications, comma, the details of which are furnished by way of a mentioning slip by the appellant, comma, to be listed along with the present applications. Full stop. All the applications shall be listed together on April 8, 2025 under the same heading. এইগুলো April 8 ওর সঙ্গে আনিয়ে নেবে।
One is a miscellaneous appeal against an injunction order. The last.
That has to be admitted first then.
Not all have to be admitted.
All are miscellaneous appeals.
No, but Order 7, Rule 11, that deemed decree.
No, that is not required to. FMAT is in
FMAT requires admission.
FMAT against what?
An order of injunction passed by the trial court. But in the suit that is still pending.
FMAT we cannot take up along with the other matters.
But kindly let it be listed. Thereafter, lordship will list it.
Cannot, Mr. Chakraborty. Let the other matters appear.
But that will create a whole lot of confusion. Let these appear before your lordship.
Very
Great.
স্লিপটা এখানে রয়ে গেল তো, এটা দিয়ে তো আনাবেন আপনি, সাবধান, আস্তে আস্তে করুন।
I am for the defendant appellant, my lord.
Anybody appearing for the other side?
No, no caveat, my lord. The appellant filed this appeal, my lord, for challenging the final degree of partition degree.
You are not satisfied with the what? With the allocated shares?
My lord, kindly see my lord, my application,
Yes.
page 85. I am challenging the my lord, report of the partition commissioner. Before the
What
Lord,
are the grounds generally?
my lord, the commissioner made partition on more than scheduled property, my lord. But kindly for a moment, my lord, 85 kindly see, my lord. Your lordship passed order, my lord. The Lorded Counsel for the defendant prisoner argues that the trial court acted without jurisdiction in accepting the commissioner report by order implemented hearing, despite having recorded that there was a clear discrepancy between the decretal property preliminary and map annexed to the deed.
Oh, we gave you liberty to take it as a ground of it.
Yes, I have clearly.
A prima facie case has been made out. No, sorry. The present appeal has been preferred against the against a final decree of partition. Push up. A prima facie case has been made out as to whether there was a clear discrepancy between the decretal property as mentioned in the preliminary decree and the map annexed to the deed in question, as well as the findings of the partition commissioner. Pushed up. Accordingly, the appeal should be heard on its merits. Pushed up. There shall be stay of operation of the impugned judgment and final decree of partition dated June 5, 2023, passed by the learned civil judge, senior division, Chandannagar, district Hooghly, in title suit number 563 of 2017 till disposal of the present application. Push up. The appellant shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing on April 28, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Another application is for the additional evidence.
What is that? Can number 2? 2. Acha. That will direct. Can 2 of 2025 is an application for adduction of additional evidence under Order 41 Rule 27 of the Code of Civil Procedure, full as per the established norms of this court, comma, the said application is directed to be heard along with the appeal. A copy thereof shall also be served on the respondents along with Can 1 of 2025, sorry, Can 1 of 2023, next para, the respondents, now the parties shall exchange affidavits with regard to Can 2 of 2025 prior to hearing of the appeal.
I'm deeply obliged.
You know, affidavit of service include the service of both.
Affidavit of service.
Serve both copies. Yes. Affidavit of service will say that you have served both.
Lordship, I appear for the respondent landlord. But the application Can 2 is pending, which is the stay application.
My lord, I'm appearing on behalf of the petitioner.
There is a section 5 also.
Section 5 has been condoned by an order dated 3rd of December 2024. So this is my affidavit in opposition, which I am filing today. And this was
yes, what do you say, ma'am?
My lord, I'm humbly seeking a not today in view of the resolution passed by the bar, my lord.
You are ready with the reply?
My lord, I do not have instructions. Allow me to come back, my lord.
Today.
Affidavit in opposition filed in respect of Can 2 of 2024 be kept on record. First of the time for filing reply thereto is extended till April 4, 2025. First up, an advance copy thereof shall be served on the learned advocate for the respondents in the meantime. First up, the application shall next be listed on April 7, 2024.
Grateful, my lord. Deeply obliged.
Thank you. আজকে তো কেউই অনেকেই করবে না বলছে অ্যাসিস্ট্যান্ট সেক্রেটারি যখন বেড়ে গেল সবাই জানে নট টুডে না থাকলো না
23, I am for the respondent.
Today, respondents will be unfortunate.
Application itself is the wrongly drafted. On the basis of wrong drafting, lordship also been passed in wrong.
Let them come tomorrow. Today you have that resolution, not today. This is appearing for the first time or no caveat?
No caveat.
Let us see the application.
But interim order is required by extending the.
We'll look into it. If there is no caveat and nobody is appearing, no service of copy, we'll take up that. You have not deposited rupees 4 Tolaban? Deposit during the course of the day. We hear the application subject to that. Do that. What is the application about?
Application about I am under the landlord as a tenant shop room. So there is no dispute in between the landlord and tenant. Defendant are the stranger. They are a cousin and aunt. Previously, that shop room was off under the
It was your suit.
your suit, my suit.
Your suit was for
Sought for declaration injunction
declaration of a tenancy.
tenancy.
But unless the main landlord was party, how could that suit be maintainable?
There is no dispute in between the landlord and tenant. There is no dispute. There's
And what is the injunction that they cannot disturb your person?
the third stranger.
Suit has been dismissed on what ground? Why was it dismissed?
Dismiss, I don't know. Dismiss on the ground. Another will is probate case is pending.
In their favor, it would go in their favor.
No,
Stranger's favor.
will was is in our favor. That is, I filed probate case. That is pending. Entire property on the basis.
But you are not claiming on the strength of your title. You are claiming on the strength of your
right.
What are you seeking now?
I am seeking now.
What is the scope of stay of that? Your suit has been dismissed.
They are disturbing the peaceful.
Declaration and injunction has been dismissed. What is the effect of stay? There is no scope of stay.
Restraining them.
Oh, this is an injunction application. ও টাইটেল সুটকে ডিসমিস করে দিয়েছে, বলেছে যে প্রবেটটা এখনো পেন্ডিং রয়েছে, কিন্তু চাইছে টেনেন্সি রাইট। টেনেন্সি রাইটের জন্য প্রবেট তো লাগে। ইনজাংশন ডিসমিস না, না সুটটা ডিসমিস করে, এক্সপার্টই ডিসমিস করেছে, কিন্তু ওর সুটটাই
all rent receipt, all things. There is no dispute in with the landlord.
Just let us check up what is the finding of the trial judge on your position, because we were asking for that also.
In judgment, stay application page 110.
What is that? Interim injunction was there.
Last order. Dismissed.
Where is your plaint? You must have annexed your plaint also. You say you sought a declaration regarding your tenancy right? Let us see your plaint.
I did not annex the plaint.
Wow. Have you got a copy of the plaint? How do you draft the application then? Or the appeal for that matter? We want to know what is the suit for.
Suit for declaration as a purpose.
We want to know from the papers, not from your mouth.
Yes, the copy.
Plaint is there.
Yes.
Hand over. You're asking for that one.
Injunction. Plaint are there. Still sorry. Plain and injunction. স্লিপটা দে, নামটা দে।
So proprietor of business বলেছি, uncontested. The present appeal arises out of the dismissal of a suit for declaration of the plaintiff stroke appellant's tenancy rights, as well as consequential reliefs of injunction and other ancillary reliefs. Push up next para. We find that a prima facie case on facts as well as law have been made out by the plaintiff stroke appellant, full stop. Accordingly, the respondents are hereby restrained by an order of injunction from disturbing and or causing hindrance to the plaintiff's possession and enjoyment of the suit property, as well as from disturbing the plaintiff stroke appellant's carriage of business from the suit property till disposal of the application. Full stop. The appellant shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing next on April 22, 2025, when an affidavit of service to that effect shall be filed. এটা ফেরত দিন। On the next day also, when we take up the application for hearing, please keep these plaint and injunction applications with you. We may ask for that again.
much humble.
Thank you. Twenty-five, 24 tour হয়ে গেছে? 24. Yes.
I'm appearing on behalf of the
Respondent.
respondent.
Correct. Yes, Mr. Mathur.
We want to file a short affidavit. Affidavit
What is the application for? Let us see
The
first.
application for injunction. They are making construction, therefore, my lord, I have filed.
What does it arise from, Mr. Mahato?
Suit is for partition and for injunction. That suit has been, my lord, has been dismissed on maintainability ground. That suit is not maintainable before the civil court. It is required to be filed before the Waqf board. On that issue, my lord, the suit has been dismissed.
Is it an admittedly Waqf property?
Yes.
Yes, for granting injunction, how long do you want to file that affidavit in opposition? Whatever time,
Within my lord 10 days, we will file.
10 days, very well.
So for the report, my lord, that deficit court fees,
Oh.
that is not correct. Because, my lord, I have paid 100. My lord, the court fees is, my lord, 80 for the partition suit and for injunction 10. But since the valuation has been, my lord, more, therefore, my lord, I think, my lord, the stamp report has given that.
Yes, yes, the revised report is there.
Yes.
Yes.
I'm good.
Oh, no, sorry. Regarding that, there is no, yes. The
Three has been filed, that has been revised report is maybe.
49,900 কেন বলছি?
My lord, valuation is 50 lakhs 25, therefore, my lord, most probably the stamp paper has given that.
50,000 maximum point.
No, 50 lakh, if you value the suit at 50 lakh, Mr. Mahato.
But partition suit, it is fixed court fee rupees 80 and injunction.
So why did you value it at for 50 lakh something?
Well, it not be ad valorem court fees, it will fixed court fees. Partition suit, my lord, fixed court fees 80. I have stated in the plaint. In the plaint that has been given. That paragraph is there. Paragraph 8, Adalate, this is the mallet.
Partition suit to
Partition fixed court fees, rupees 80.
ও আর কি চেয়েছে আর কোনো রিকোয়েস্ট মিস্টার মাধব ডিড ইউ সিক এনি আদার ইনজাংশন আদার ডিক্লারেশন
No. Kindly see the plaint.
consequential to which না পিওর পার্টিশন ফিক্স করতে হবে এটা হচ্ছে ফেরত we find from the plaint of the suit from which the present appeal arises, comma, a copy of which has been handed over to us by learned counsel for the appellant, that the suit is one for partition simpliciter, push up as such, comma, fixed court fees of rupees 100 were required to be paid. Push up
90. I have paid 100.
or rupees
80 plus 10.
rupees 80 was to be paid for the relief of partition and rupees 10 for injunction. Push up next para. However, comma, rupees 100 has been deposited by the appellant. Push up as such, comma, we find that the report of the stamp reporter to the effect that there are deficit court fees be ignored. Push up the appeal is found to that such defect be deemed to stand cured. Push up next para. The appeal arises out of the dismissal of a partition suit primarily on the ground that it is not maintainable since the same had been filed before the appropriate authority under the Waqf Act. Push up, since a strong prima facie case for hearing of the appeal has been made out, as the property is admittedly a Waqf property and no adjudication in that regard was required, comma, we find that the appeal should be heard on merits on such questions and the other grounds taken in the memorandum of appeal. Push up, accordingly, there shall be injunction restraining the, you are appealing for who are the caveators? Acha, accordingly, there shall be injunction restraining the respondents from you are in possession, there is no finding in that regard. And if this is a partition suit, possession will say status quo, Mr. Mahato, and regarding the other aspect of the matter,
To change the nature and
that will come. Restrained by an order of injunction from transferring, alienating, and or encumbering the suit property and or any part thereof, as well as from changing the nature and character of the suit property till disposal of the application. Push up, the parties shall maintain status quo as of today in respect of the possession with regard to the suit property, also till disposal of the application. Push up, on the prayer of the caveator stroke respondent numbers 1 and 2, comma, the respondents are directed to file their affidavits in opposition to the application within of within April 16, 2025, full-stop reply, if any, shall be filed by April 23, 2025. The application shall next be listed for hearing on April 28, 2025. Full-stop. In view of the appearance of the caveators stroke respondents 1 and 2, comma, service of copies of application is dispensed with on the said respondents. Full-stop. However, comma, the appellant shall serve copies of the application on respondent numbers 3 to 14 and file an affidavit of service in that regard on the returnable date.
ওয়াকফ প্রপার্টি অ্যাডজুডিকেশন যখন ডাউট আছে, একটা আনএক্সপেক্টেড কেস ছিল যে সব প্রপার্টি, তারপর সেটা মডিফাই হয়েছে। যদি ওয়াকফ প্রপার্টি অ্যাডজুডিকেশন না থাকে তাহলে হবে না। ওই অ্যাডজুডিকেশন একটা লিমিটেড কনটেক্সটে শুধু ওয়াকফ বোর্ডের কাছে যা প্রপার্টি পার্টিশন প্রপার্টি।
But I am for the appellant, Milord.
First time,
Milord, there is application for injunction. I believe, Milord, there is no caveat, Milord, lodged.
But some defect has been pointed out. Let us check up.
Milord, the deficit court fee has been, Milord, put in.
Because report is there.
Yes.
Mr. Rai is there, he knows. He must know. What is the
Milord, the objector is the Milord appellant before your lordship in probate proceeding, probate granted. It's my brother's property. Brother's died bachelor, Milord, one of the tenant in respect of that premises, Milord, that is the suspicious circumstances, Milord, that Milord, the
tenant has been?
Milord, that has been, Milord, the property has been alleged to have been bequeathed, Milord, to that tenant.
What is the suspicion in that?
That is not only one ground, Milord. Milord, she said she is residing and she was looking after my brother.
Yes.
On the contrary, it was not proved that she was there, Milord, in 1998 when he was married first time. Thereafter, divorce took place and thereafter second marriage, and she, Milord, left this property and she was living, Milord, separately.
Very well. Since a prima facie case for hearing of the appeal has the present appeal arises out of the grant of a probate by the impugned decree. Full stop. Since a prima facie case for hearing of the appeal on merits has been made out, comma, as well as the balance of convenience and inconvenience is in favor of such grant of injunction, comma, the respondents shall remain the respondent shall remain restrained by an order of injunction from changing the nature and character of the suit property and stroke or from creating any third party interest in respect thereof till disposal of the application. The appellant shall serve a copy of the application on the respondent, indicating that the application shall next be listed for hearing on April 21, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Great.
We'll continue after some time.
Lordship, I am for the appellant.
Is there any caveat or other side appearing?
No, Lordship.
Appearing for the first time.
Lordship.
What is the matter about?
Lordship, I want to withdraw the appeal. Lordship, kindly see the stamp reporter's report, Lordship. My learned friend without
They're
knowing
not
the-
letting you withdraw because of the defect or what?
No, Lordship, the pecuniary jurisdiction is, that is the point.
So you have to go before the
Lordship.
learned counsel for the appellant submits that since the appeal has been filed before this court erroneously, comma, the appellants seek to withdraw the appeal. Full stop. We also filed from the report of the stamp reporter that the appeal has been filed wrongly before this court, taking into account the pecuniary jurisdiction. Full stop. Accordingly, FAT 63 of 2025 is FAT 63 of 2025 along with CAN 1 of 2025 are dismissed as withdrawn with liberty to the appellant to file afresh before the appropriate court having jurisdiction. Full stop. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the copies of the judgment and decree impugned herein upon furnishing photocopies of the same for the records. No rest to cost.
Lordship, court fees can be adjusted.
Very difficult. Different courts, it's difficult. If it was district court and civil judge senior division, it would be easier. How much have you put in?
It's near about 7,000.
Leave is granted to the appellants to file an appropriate application before the court where the appeal shall now be presented for exemption regarding the court fees which has already been filed, deposited in connection with the present appeal.
For the appellant, it's coming for the first time.
First time. No caveat also, obvious.
The application, the suit was filed for declaration and injunction in respect of one tenanted.
You had to put in Tolabana rupees 4 and written up notice form, not deposited. That direction was given within 2 days, 2 weeks from the date positive.
Probably it has been deposited.
Deposited. Let us just check up.
All directions have been complied with. I was told.
There is no further report. This is dated 26th of March. When did you deposit? Have you got copies of that?
But in that case, I will deposit.
Please deposit and
some urgencies are there.
What is the appeal arising out of what?
Arising out of order and judgment passed by the Honorable City Civil Court, my lord.
For?
In respect of my lord, suit was filed. I was a tenant in respect of my premises.
Eviction?
No, my lord. It was a peculiar case. The declaration and injunction, my lord. Initially, the tenancy was created in the year 1975.
You were the defendant in the suit?
I was the plaintiff. I was the plaintiff.
Declaration of your tenancy right?
Declaration of the tenancy.
An injunction?
Now, my lord, that tenancy continued for a considerable period till 1999. In the meantime, my lord, in 1983, the original tenant, original tenant expired. Now, as per the section 2H of the Western Premises, it's a hereditary right, my lord, which has bestowed upon the widow and the sons and daughters. Now, in 1999, my lord, a fire broke out in the Park Mansion in 57 and considerably damaged the tenancy property. Now, my lord, we made an application before representation before the consent to at least to repair so that we can at least be reinstated. Now, that was not done, my lord, which compelled us to file a suit before this City Civil Court in the year 2000, before the commencement of the new act. The commencement took place in 2001 and we filed the suit prior to that, and our tenancy is gone by the old act. Now, my lord, the learned court, my lord, on appreciating all the facts, my lord, has framed 6 issues, out of which 4 were decided in my favor, upholding my right of tenancy, but said that under the new act, I cannot compel the landlord to repair. Although, my lord, that finding is self-contradictory in itself, because, my lord, in the previous paragraphs, the learned judge held that my tenancy is governed by the old act, so new act.
Even if it is governed by the old act.
Even if
After the coming into force of the new act,
even if
after
I
that
have the
section.
Honorable Apex Court judgment, my lord, in the recent 2024, which says that if the tenancy is created as per the old act, that it governs. The old act comes, a new act never takes away in the right to that effect.
You've got a Supreme Court judgment to that
Yes.
effect. Cite that. 2H would not come in even after the date of enactment of the new act.
No, I filed a suit before the commencement of the act.
Yes, but by operation of law after a certain period from
No, that is the
either
new
from
act.
the death or from the date
That
of
is the
commencement.
new act which has been held by the Honorable Apex Court is not applicable in those cases where the tenancy, my lord, this is the judgment.
This is an unreported judgment.
No, my lord,
What is the citation? Give us the citation also.
unreported judgment. And this judgment has been taken note of by this learned court below. Kindly see, my lord, internal page 11, paragraph 16 onwards. May I read, your lordship, please? The current position of law as it seems from the decision of the Calcutta High Court is that the 1997 Act represents a shift of legislative intent, while the 1956 Act approached tenancy as a heritable right that can be claimed by legal heirs of an original tenant. This position was changed by the 1997 Act to provide a limited protection of 5 years to the specific heirs of an original tenant, and as per the High Court, in cases where original tenant had died during the existence of old Act, 5 years shall be counted from the commencement of the new Act. In our considered opinion, the above view of the Calcutta High Court cannot be sustained. The High Court in this case of Gautam De has held that the new statute which touches upon the existing right cannot be retrospective without an express provision or necessary implications expressing the clear intent of the legislature. Gautam De Supra relied upon Section 8C of the West Bengal General Clauses Act to say that a new statute does not affect the existing right. Section 45 of the 1997 Act repealed the 1956 Act, but that cannot mean that the rights accrued under the old Act are extinguished altogether with the enforcement of the new Act. The enforcement of a new statute ipso facto will not take away the right already accrued under a repealed statute unless this intention is reflected in the new statute. The court in CIT versus Vatica Township reiterated the general principles concerning the retrospectivity of the statutes. This is what was said of the various rules guiding how a legislation has to be interpreted. One established rule is that unless a contrary intention appears, a legislation is presumed not to be intended to have a retrospective operation. The idea behind the rule is that a current law should govern current activities. Law passed today cannot apply to the events of the past. If we do something today, we do it keeping in view the law of today and in force, and not tomorrow's backward adjustment of it. Our belief in that nature of law is founded on the bedrock that every human being is entitled to arrange his affairs by relying on the existing law and
But I mean, with due respect, I mean, this is a statutory tenancy which is being created. The tenancy is being created by a statute. So that can definitely be taken away by a statute.
Ultimately, it was held that, my lord, the right.
This is not a right of tenancy. This is not a contractual right of tenancy which is continuing. Contractual right definitely cannot. But this statutory
It's
protection.
not a statutory right, my lord.
You are a statutory
No,
tenant. Absolutely.
I am a statutory.
Your right of tenancy is totally statutory after your lease is determined. You are only there because of the statute. If the statute was not there, you would be, by expiry of time, you would go be gone, or by a notice.
Yes, but my lord, this was never determined. Now, in the foregoing, the last.
Yes, we have seen 2G has been dealt with.
Yes. Now, that case, my lord, the.
Very well. Yes, we'll come to injunction. An arguable question has been raised to the effect as to whether the learned trial judge was justified in dismissing the suit of the appellant seeking declaration of his tenancy right and consequential injunction on the ground of the operation of Section 2 within bracket small h of the West Bengal Premises Tenancy Act 1997, which of learned counsel for the appellant contends that the tenancy rights of the appellant were accrued pursuant to the predecessor act, predecessor Rent Control Act to the 1997 Act, that is the West Bengal Premises Tenancy Act 1996, whose of learned judgment cites a judgment of the Supreme Court an unreported judgment, an apparently unreported judgment of the Supreme Court in the matter of Rajesh Mitra alias Rajesh Kumar Mitra versus Karnani Properties Limited, decided on September 20, 2024, where prima facie it has been held that a right conferred by a previous statute cannot be taken away by a new statute, comma, going on to interpret the same in the context of section 2 within bracket small g of the 1997 Act. Hence, comma, the appeal is required to be heard on the above issue as well as the other grounds taken in the memorandum of appeal. Full stop. There shall be, accordingly, there shall be an order of injunction restraining the respondents from evicting and or
My lord, I am not in possession of this property. I am not, because the fire has.
Then what
damaged-
injunction order can?
No, they should not at least alienate the property, my lord. A third party right
That
should
is
not.
beyond your prayer made in the injunction application.
No, my lord. I have already made that prayer.
Let us see. Forcibly evicting is also there, but the second part. Thereby restraining only the respondent number 1.
Yes, my lord.
Thereby restraining the respondent number 1 from alienating and or encumbering the suit property in favor of any third party during pendency of the application. First of the appellant shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing next on April 22, 2025, when the appellant shall file an affidavit of service to that. The appellant shall cure the defects by depositing the talabana of ₹4 along with written up notice forms for effecting service of notice of appeal upon the respondent of 1 to 3, comma, which time is extended till tomorrow. Full stop. It is made clear that the event of non-compliance of the above direction, comma, the above injunction order shall stand automatically vacated because there was a previous direction. Do it today.
Yes, I will do.
₹4 চালাবান and postal requisite. আচ্ছা, একটা জিনিস অ্যাড করে দাও অনেকটা, shall comply, যেটা বললাম ডিরেকশনটা দিলাম, if not already done.
Let 120. I was told on.
If already done, keep the papers in your
24th
hand. Keep the papers in your hand when it is next taken up. Yes. We have put in if not already done. Mr. Mukherjee, you are there? 29 is, acha, order for 10. No, application. You are for the appellant.
Ma'am.
Is it appearing for the first time without any caveat?
There is no caveat.
What is the matter arising out of, Mr. Mukherjee?
Arising out of a suit by which actually the mother, she created a deed of gift in favor of the daughter. Now she was otherwise taken over by the son. And the son forced the mother to file a suit. That suit was finally decreed in favor of the mother is dead on the brother, who has now become the plaintiff respondent number 1 in this case. Now there is every possibility of the property, which is a joint property still, but can be disposed of or alienated by the respondent number 1 at any point of time. That is the
Their rights have been declared and injunction has been granted against you.
No
by the
injunction has been granted against me.
What is the impugned degree?
Impugned degree is the deed of gift has been set aside.
Oh, the deed of gift in your favor was set aside?
Yes.
Acha.
I can give you the short history of this particular matter.
Now we want to know the nature of the decree only.
Nature of the decree, my lord, the decree is on record. Starts from page.
Just we'll see the ordering portion, Mr. Mukherjee.
Operative portion is
Yes, yeah. The declaring is required and liable to be. Yes, permanent injunction has been given also, restraining you from alienating, transferring. You want a similar injunction against them?
Against only respondent number 1.
Acha, very good. Since a prima facie case for hearing of the appeal on merits has been made out, comma, the respondent number 1 is restrained by an order of injunction from dealing with and or transferring the suit property comprised at premises number 36 capital A, Pyari Mohan Roy Road, comma, Police Station Chetla, Kolkata 7,27,000 in favor of any third party till disposal of the application. Full stop. Since no reliefs have been sought against the pro forma respondents, comma, service of notice of the application on the said respondents is dispensed with for the present. Full stop. the appellant stroke petitioner shall serve a copy of the present application on the respondent stroke opposite party number 1, indicating that the matter shall be that the application shall next be listed for hearing on April 21, 2025, when an affidavit of service in that regard shall be filed by the appellant.
Number 30, my lord, I am for the appellant.
Appearing for the first time.
Appealing for the
What
first
is the
time,
appeal
no
against?
My lord, appeal against, my lord, the appellant is a pre-mortgage tenancy, is a bona fide tenant under the respondent number 2. My lord, rent receipt is also produced before the loan was taken even. So after subsequently 13-2 was issued, my lord, they filed an order 7 rule 11 and lower court allowed that order 7 rule 11 dismissing my suit. Although the fact that that is a pre-mortgage tenancy, my lord, I have in the can 1, I have
You have sought for a stay.
Stay, can 1.
Stay, I mean, what would
Stay, my lord, since my lord, the bank employees, what they are doing, they are coming to my
stay of operation does not mean anything, but 7-11 would be revived then only.
7-11 filed by the bank.
That has been allowed.
That has been allowed.
Stay means that will be revived.
Stay of that order, impugned order.
Stay of rejection of plaint means the plaint revives and the suit becomes alive again. There is no meaning to stay.
My suit, my lord. I understood. So bank employees are now at presently, my lord, they are coming.
So there has to be an injunction also.
Injunction also you paid, my lord.
You have captioned it as a stay. But we'll put in due process of law without due process of law.
Pair B, my lord. An order for decree for order of permanent injunction restraining the defendants in.
There is no B in our copy.
My lord, can 1.
Can 1, there is no prayer AB. It's a composite continuous prayer.
Can 1, page 25, my lord. Page 25 of can 1.
What is the appeal? The name of the plaintiff appellant?
Shekhar Kumar Saha.
Shekhar Kumar Saha. The can 1 is an application for stay. Page 15 is the prayer.
Page 25, my lord. Oh.
That is probably the trial court's injunction.
Trial court's injunction.
If 15 is the present prayer, then it must be you must be reading the trial court's prayer. Anyway. The appellant has made out a prima facie case for hearing of the appeal, which has been directed against the rejection of a plaint in the plaintiff's suit for declaration and consequential reliefs, in view of the plaintiff stroke appellant being allegedly a pre-mortgage tenant and the learned trial judge having come to a finding that the plaintiff is also amenable to the provisions of the Surfacey Act and the appropriate remedy would be under the said act. Hence, further, we find that a case of urgency and balance of convenience has been made out in favor of grant of injunction. Accordingly, the respondent
number 1 is the landlord, respondent number 2 is the bank.
Accordingly, the respondents shall be restrained by an order of injunction from disturbing the peaceful possession and enjoyment of the plaintiff stroke appellant in respect of the suit property without due process of law till disposal of the application. The appellant shall serve copies of the application on the respondents, indicating that the same shall be listed for hearing on April 21, 2025, when an affidavit of service to that effect shall be filed by the appellant. Without due process of law, crucial. Yes.
Even my lord's judgment is also there on that point. That
so there are several judgments. Pre-mortgage. Section 17 is would not suffice probably. Anyway, let us hear the other side. Here for the respondent.
As for caveat.
Today is a bad day for respondents. We'll just make it not today. Not today.
Matrimonials.
Oh, that strike. Tomorrow, if they don't come, we'll take up. You have already remarried?
No.
Don't. Within one day, don't. Yes.
32 lossy, I am
Yes, Mr. Das, what is the matter?
Suit for money suit, defamation.
These 4 rupees are adding up to much. I mean, in all the matters, 4 rupee Talabana not given, put in.
Lossy, I not seen this.
There is no caveat.
No caveat, usual PR lordship, call for the lower court by patient messenger and notice by speed post and the direction for informal paper book.
The appeal is against what?
Money suit. Suit was
Dismissal.
dismissed.
You are asking for early hearing and you have not put in the Tolomana.
Lordship is just
Anyway.
no.
In view of the innocuous nature of the application, comma, prior service of notice is not required, not deemed to be required. Push up next para. The application, the appellants seek early disposal of the appeal. Push up accordingly, can 1 of 2025 is disposed of by directing the appellant to put in postal requisites and Tolobana as well as written up notice forms for service of notice of appeal on the respondents, comma, within a week from date. Push up the trial court records be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who is of liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. No address to costs.
Item 31, my lord said not today. Can it be not tomorrow?
We have not recorded any order because today that.
Because tomorrow I am some difficulty.
You would have some difficulty. Previous matter?
Yes, 31.
31.
Lordship said not today.
Acha, 31 টা order record করো না none appears for the appellant although the respondent is represented. Push up. Learned counsel for the respondent submits that he is in some difficulty tomorrow. Push up accordingly. Let the matter stand adjourned till April 7, 2025.
Wait.
Not today. না থাকলে not today. অর্ধেক থাকবে না. Same. Same.
36 I appear for the appellant.
There is no caveat, Mr. Bhatt. Good.
No, there was direction for putting in the deficit court fee, my lord, which we have done. The deficit court fee was put in, my lord, on 26th of March.
Do you have anything to that effect? I mean,
It's
put in something we'll record.
transpires from the case records, my lord. It's online, my lord.
A transcript of the online information indicates that deficit court fees have since been deposited by the appellant, pushed up. Accordingly, the defect in that regard be deemed to stand cured. No, there's a report to that effect also. Anyway, please continue. We'll hear it under order. Yes.
My lord, the plaintiff in a suit for declaration of title.
First, say judgment of affirmance or reversal. Very well.
The plaintiff in a suit for declaration of title, possession, and a further declaration that the deed of gift executed in favor of the defendants by dint of which they claim title to the property is illegal, inoperative, and void. So these are my three prayers, my lord.
You are the plaintiff.
I'm the plaintiff. My lord, I seek a declaration of my right, title, interest in the property, also of my possession, and a declaration that the deed of gift, by virtue of which the defendants stake claim to the property, is void. And with injunction, my lord. Now, my lord, the trial court frames issues. It holds that the title lies with me. It holds the valid title in my favor. It also holds the deed of gift, which I assail, is also void. But it dismisses the suit only on the ground of maintainability that I had not prayed for a prayer for recovery of possession. Upon a finding entered into by it, saying that I was not in possession. The appeal court affirms the judgment. 2000 judgment.
No, but what is your case that you are in possession?
I filed the suit claiming I was in possession. I filed the suit seeking declaration of my right title interest.
Understood.
So, the court holds that the right title.
No, you got an injunction in the meantime. No, then that becomes a necessary relief, but under the new judgment, section 34 does not apply.
But today, my lord, what I'm on is very simple, my lord. The trial court holds that I am the title holder. The equal trial court also holds that the defendant has no locus, in the sense that
it could have at best refused the injunction.
Yes. This is my suit.
The second appeal shall be the present second appeal shall be heard on the following substantial question of law: whether both the courts below substantially erred in law in dismissing the plaintiff stroke appellant's suit for declaration of title as well as declaration that a gift deed is void, comma, along with consequential relief of permanent injunction, comma, in the teeth, despite having held in favor of the plaintiff having title as well as the gift deed being void, comma, only on the ground that no prayer for recovery of possession was sought, comma, since after final hearing, comma, the courts were of the opinion that the plaintiff was not in possession. Next para, whether in view of the plaint case being that the plaintiff was all along in possession of the property and only at the final hearing stage the courts below having come to the finding that the plaintiff is not in possession, comma, whether the suit can be said to be barred under the proviso to section 34 of the Specific Relief Act 1963.
One more issue, Milord. There's one more issue. Written statement was not filed. Now the court construes the objection to the injunction application as the written statement.
At the third ground at corner, whether the courts below could have construed the written objection to the written statement, written objection to the injunction application as a written statement filed in the suit, comma, contrary to the provisions of orders 6 and 7 of the Code of Civil Procedure. At the third ground, what is the application?
No, that's also restoration, Milord. That's the restoration.
Restoration had to be allowed first. Then.
Allowed. On the last.
So no other application. A suit has been dismissed. So we'll direct you to put in. The appellant shall prepare and the appellant shall put in postal costs and other requisites for service of notice of appeal on the respondents within a week from date. Push up the trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file informal paper books without comparing with the records within 4 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Liberty to the appellant to mention before the appropriate learned single judge having determination for inclusion in the list for hearing as and when the appeal is ready for hearing.
I'm so grateful.
Thank you.
জাজমেন্ট আছে সুপ্রিম কোর্টে যে লাস্ট থেকে তুমি যদি দেখো যে ইয়ে নেই পজিশন নেই তাহলে সেকশন 34 ভ্যালুয়েবল ডিসপিউটেড সময় আছে তখন বলতে পারবো যে সেকশন 34 ছিল
Matter I'm led by Rajoshi Dotto in this matter.
Not today.
Grateful.
39.
Here for the other side. Yes.
My lord, the last occasion, my lord, grant her time to take instruction.
Yes. Have you taken instruction?
They don't have any problem. Lordship, if the name
No problem to what?
if the name is there,
Appeal,
We have forgotten.
appeal has been filed against allowing an application under Order 22 Rule 10, expunging name of the appellant and impleting the name of the assignment.
Oh, regarding the transfer, there is a suit pending.
Yes. During pendency of the suit, she has transferred his.
Your name has. So you have no objection. Can we record that? But we cannot allow an appeal. We have to. We'll record that you are conceding to his contentions, but we'll also have to allow the appeal on merits because we can dismiss appeals on consent, but we cannot do very well. We admitted the appeal previously.
Yes.
Appeal was admitted.
Admitted.
Very well.
Section 5 has been allowed.
No, section 5 has been. Yes, it was admitted. No. Yes, appeal has been admitted. Learned counsel for the respondent, comma, on instruction, comma, submits that the respondent has no objection to the appeal being allowed in the limited context that by the impugned order, comma, the name of the appellant has been expunged as a party to the suit on the strength of a transfer deed in favor of a third party. Push up next para. Upon hearing learned counsel for the parties, comma, we find that the appeal arises out of a suit. You are the defendant in the suit. A suit filed by the plaintiff stroke respondent for partition and consequential reliefs, pushed up in the said suit, comma, An application under Order 22 Rule 10 of the Code of Civil Procedure was filed by the plaintiff seeking to impede the alleged transferee of the appellant, by dint of a purported transfer deed executed by the appellant in favor of the third party. Push up. The learned trial judge, by the impugned order, not only added the said alleged transferee but also expunged the name of the appellant. Push up. It is contended by the appellant. There is a separate suit pending. Contended by the appellant that there is a separate suit pending challenging such purported transfer and, as such, in the event the appellant is expunged from the array of parties in the partition suit, the same would be premature, since the veracity and legality of the transfer deed, which is the basis of such expunction, itself being sub judice. Pushed up, we find a substance in the contention of the appellant, in such view of the matter, and taking into consideration the concession of the respondent, FMAT 240 of 2024 is allowed, thereby setting aside the impugned order. Push up next para, can 1 of 2024, setting aside the impugned order, detailed particular take to the setting aside the impugned order, bearing order number 44 dated October 10, 2023, passed by the learned civil judge senior division at Ranaghat, district Nodia, in title suit number 147 of 2018. Push up next para, can 1 of 2024 and can 2 of 2024 also stand disposed of accordingly. There will be no arrest to cost. এটা judgment format হবে, appeal to dispose. Thank you. তোমরা একটু খেয়াল রেখো। Not today. উনি পরে matter. Yes.
Paul Boss is appearing, my lord. I am playing not too long.
No, granted. Not true. Hearing bill is this one. Just guess one. What's that article? 42. Not today. Order for term takes 40 of Yes, Bishop, yes. Is there any caveat?
No, no caveat.
Let us just let them find out the file first. Is a Ghosh is also in this matter? Pardon? Yes. ঠিকঠাক ফাইলটা দেবেন পুরো ম্যাটার শুনে তারপর দেখবো অন্য লোকের মামলা
But defective is there.
Yes, what is the defect, Mr. Shaka? That was what
Defective is for sent down to the trial court for rectification.
no, not anything to do to be done by you.
I have the last.
No, you have to effect rectification in the cost title. Oh, once it is received back. Yes, yes, you have checked up also. Yeah, what is the matter?
The plaintiff appellant is before your lordship. The judgment of reversal was sued for partition, praying for preliminary degree.
Yes.
In respect of 49.5.
Decimal.
In schedule call. Well, previously sued property was owned by one Mohor Roy. And his name was recorded in CS record of right. Then Mohor Roy died. So after Mohor Roy died, his only one son, Shanti Roy. Is this a property? And Shanti Roy thereafter transferred 49.1 and 2 decimal of core schedule in respect of in favor of Krishna Prasad Gupta, my predecessor in interest of the plaintiff. Krishna Prasad Gupta. Krishna Prasad died.
Mohan and all his son, they were the absolute owners of the property.
Yes.
Exclusive absolute owners.
Yes.
So sold the entire property to this.
Yes. 49.
Did not sell the entire property.
No, no.
Sold a demarcated portion of the property.
Yes. 49.5 decimal my property.
Undemarcated or demarcated?
Demarcated.
Then it remained joint.
Yes. Now the Shanti Rai transferred 49 Krishna Prasad.
To you?
Krishna Prasad Malad died. Krishna Prasad Malad after day Malad.
You are through Krishna Prasad, yes.
Thereafter Malad fact is that the trial court Malad decreed the suit and Malad declared 49.5 declared. But Malad
Trial court passed a preliminary decree, Ms. Sarkar.
Yes. Yes.
Why did it, was it reversed?
Yes.
Why was it
Because not want of necessary parties.
Why not?
Other co-sharers were not made parties. That's why Malad.
You have to make the other co-sharers parties.
Yes, well, that is one of my grievance. Well, you send down for remand. Otherwise, to amend.
You should have been given an opportunity to.
Yes, yes, to amend. There is a there's your lordship kindly. One.
Yes, yes, sir. Yes.
In suit for partition. For all the take all lectures, Mitra's book, refer. All the parties.
Whose book, Ms. Sarkar? Library's book.
No. Mrs. Sudhir Das.
Yes, it appeared. That's why I asked specifically.
Yes.
We could trace the source.
Yes.
Yes.
In a suit for partition, all the parties who have any share in the property have to be implemented either as
Yes, partition should always. And even in other suits, if it is dismissed for non-joint, it's a technical dismissal. Courts have to give opportunity.
Judgment on
The present second appeal will be heard on the following substantial question of law: whether the learned first appellate judge erred in law in reversing the preliminary partition decree granted by the court of first instance merely on the ground of non-joinder of parties, without granting an opportunity to the plaintiff/appellant to implead the left-out parties, particularly keeping in view that the cause of action in a partition suit is of a continuous nature. Any application, Mr.
application for injunction, you'll also kindly come to page prayer, page 14. Your petitioner for the prayer interim on restraining the defendant, respondent, opposite parties from disturbing the peaceful possession of the petitioner.
Regarding possession, yes, trial court granted preliminary decision.
The changing the
Regarding possession, Ms. Sarkar, if you grant a status quo regarding, we will grant a status quo regarding possession because we don't know exactly what position.
Selling in
That will grant regular injunction.
I appeal.
Since a prima facie case has been made out and the second appeal has been admitted on the above substantial question of law, the second appeal is required to be heard on merits. So we also find the grounds of urgency and balance of convenience as well as irreparable injury having been made out in the application. Accordingly, the respondents shall remain restrained by an order of injunction from selling, transferring, alienating and or encumbering the suit property in favor of third parties till disposal of the application. The parties shall also maintain status quo with regard to possession in respect of the suit property, also till the disposal of the application. The appellants shall serve copies of the application on the respondents, indicating
1 to 11, my lord. 12, 13, my lord, pro forma dependent.
আচ্ছা ইনজাংশনটা যেটা দিলাম সেটাও রেসপন্ড নাম্বার 1 to 11 রেজিস্ট্রিং সার্চ আর এটাও কন্টিনিউ করো সার্ভ কপি নো ইটস আ পার্টিশন স্যুট নো তুমি কোনটাই রেস্ট্রিক্ট করো সবকটাই রেসপন্স করো হ্যাঁ shall serve copies of the application on the respondent numbers 1 to 11 as well as না ওরা তো রেসপন্ডেন্টই ডেসক্রাইব করেছে প্রোফর্মা কেটে দিয়েছে ঠিকই আছে on the respondents করে দাও on the respondents indicating that the application shall be listed before the appropriate learned single judge having determination. The appellant shall file an affidavit of service before the said learned single judge when the application is next taken up for hearing. It will appear before the learned single judge with.
I'm grateful to you.
Thank you. হ্যাঁ ঠিক আছে বলে গেছি
নামটা দিচ্ছি
না নট টুডে এই ওদের আর্দালিদের ডেকে নিতে বল কল করে যান 45 নট টুডে সেম is there any hearing matter where any other matter where both the parties are appearing.
My lord, in
Yes,
item
you are
40, my lord, item 48, my lord, I am for the appellant, your lordship. I'm
48.
praying for accommodation, your lordship, in view of
Yes,
the.
yes, yes. 48, we are not taking up any matter unless both the sides are there because of a strike called by the bar association. So by default, you are getting a not today. No difficulty on that. We are not recording any order. If both sides are not present, then we'll rise. কি আছে আর্দালিরা কোথায় গেল একজন তো বসে আছে একজনকে ডেকে নিতে হবে হ্যাঁ উঠে যাই
কিন্তু